I'm Steve Vladeck of the class of 2001, which somehow is now in our 10th reunion year. I don't know how I feel about that, but I guess ask me later. And thank you all for coming. Today's talk is about Hamdan versus Rumsfeld, my experience in that case, and I also thought maybe to use it more generally as a foil for a broader discussion of the role of the Supreme Court in the war on terrorism, where things stand today, and what some of the big picture issues are going forward. At the outset, let me just say thank you to the class of 2001 for sponsoring this, to the alumni office for helping to put this together, and to all of you for being here when it's so nice outside. My plan for this afternoon is to talk for about 20 or 25 minutes and then throw it open to discussion and Q&A. But I hope you'll feel free, if I'm going too quickly or if you have questions along the way, to just raise your hand, interrupt me. My students certainly do. So we'll see how it goes. So when I was asked to give this talk, I was trying to think of what would be an appropriate way to think about how the last decade has progressed. And it struck me that our class is coincidentally the class that will always be tied to 9/11. It was just a couple months after we graduated. It was my second day of law school. I was in Guido Calabresi's torts class, which is about as weird a place to be for that event as possible. But the thing is, one of the remarkable things about the fact that it's now been a decade, both since we graduated and since 9/11, is that in some ways we haven't come very far. So for example, I'm talking about the case of Salim Hamdan. Ironically enough, Hamdan's case is still pending. Just about a month ago, there was argument to the en banc Court of Military Commission Review, and I'll tell you a little bit about that later, in the appeal of Hamdan's ultimate conviction by a military commission. And so I think one of the themes that I hope will come out in my remarks today is that we've made some progress over the last decade, but it's been very slow progress, and it's been a very distinct kind of progress. So let me sort of start at the beginning, because I suspect not all of you are as deeply familiar with the legal events of the last 10 years. 1 week after 9/11, on September 18th, President Bush signed into law the AUMF, the Authorization for Use of Military Force, which is still the statute governing most of the government's policies vis-a-vis the war on terrorism. If you've been reading the papers, you might have seen just yesterday, the House of Representatives passed, as part of an amendment to the National Defense Authorization Act, a new AUMF, which would, in theory at least, reiterate and in some's view, expand the scope of the conflict Congress authorized way back in September 2001. But say what you will about current events, September 18th is when everything started. 2 months after that, President Bush issued a military order creating military commissions, ad hoc trial courts that were designed to try non-citizen terrorism suspects picked up as part of the war on terrorism. Indeed, in the same month, we started detaining individuals captured on the battlefield in Afghanistan, first in Afghanistan and then eventually in Guantanamo. Now, as the model for these military commissions, the Bush administration relied on a fairly controversial 1942 Supreme Court decision called Ex parte Quirin. Quirin was about 8 Nazi saboteurs who had surreptitiously snuck into the United States in the spring of 1942, and who, their best efforts notwithstanding, were not caught by the FBI until they turned themselves in. The story of Quirin is actually worth a talk in its own right. I'll just give you my favorite point. The first time that the lead saboteur called the FBI and said, "I am a Nazi here on a mission of sabotage," the FBI told him that it was a crime to make crank calls during wartime. And indeed, part of why Ex parte Quirin is a controversial precedent is because some believe, including figures like Justice Frankfurter, Justice Scalia, that one of the reasons why the FDR administration was so interested in brushing this whole episode under the rug was to keep secret some of these staggering defensive vulnerabilities that the case of the 8 saboteurs had highlighted. But be that as it may, Quirin stood as a controversial but extant precedent for the proposition that it was okay, even when the civilian courts were open and functioning, to try enemy combatants during wartime for violations of the law of war. And so the military order that President Bush issued in November of 2001 was designed with that idea in mind, right? That in fact, what these individuals were going to be tried for was violating the law of war. Shortly after the military order, you start to see the first habeas petitions arising out of Guantanamo. Habeas petitions are a classical legal remedy designed to test the legality of detention. And these cases were at least a little bit different from Hamdan. These cases were detainees who weren't slated for trial by military commission. They were being held without charges. And the purpose of their habeas petition was just to adjudicate whether they could be held indefinitely. Those cases are proceeding at the same time as the military commissions, and in the early rulings in those cases, first the Federal District Court in Washington and then the US Court of Appeals for the DC Circuit hold that there is no statutory jurisdiction, that the federal courts don't have the power to hear the Guantanamo habeas claims because the statute doesn't extend to non-citizens who are held outside the territorial United States. The reason why those cases matter is because this is where my rather small role in the story begins. I was a law student when I got a very strange phone call from Neil Katyal, who at least then was a professor at Georgetown, who's now the acting Solicitor General for, I think, what, another 10 days? So Neil says, Steve, you don't know me. And I said, true. He said, but I'd like you to come work with me in this case challenging military commissions. I said, what case challenging military commissions? He said, well, you have to say yes before I can tell you anything. I thought that was a rather strange employment agreement, but you know, I was a 2L, what did I know? Anyway, so the reason why I was brought into the case is because Neil had asked his law school mentor, a Yale Law School professor named Akhil Amar, for someone who was a real nerd when it came to hyper-technical questions of federal jurisdiction. I thought it was for my height, but apparently not. And the issue was simple. Hamdan was trying to find a way. By this point, Hamdan had been the first defendant who had been slated to be tried in the military commission. Hamdan was not exactly a particularly important detainee. The most serious allegation against him was that as Osama bin Laden's driver, he once transported a missile. Although that particular claim was never proven. Rather, Hamdan was a test case. Hamdan was the Bush administration's approach to attempt to have one case go through the commissions to sort of sort out all the wrinkles so that the bigger cases of the more high-profile defendants could follow. Hamdan was charged in 2003, at which point the federal courts in DC had held that there was no habeas jurisdiction, that the federal courts couldn't hear habeas petitions coming out of Guantanamo. So my job was to come up with another theory for why the federal courts would have the power to hear Hamdan's challenge to his military commission, even if they couldn't hear the typical case brought by a detainee who was simply challenging his detention without trial. I thought I had a pretty good idea. I don't know. It was never really tested. But so the theory that we ended up filing on was that Hamdan wasn't just entitled to habeas relief, but Hamdan was actually entitled to something called a petition for a writ of mandamus, which is a different kind of common law remedy, because Hamdan had a right not to be tried by a military commission that was itself unlawful. That was our rather thin justification for why there should be jurisdiction over his case, and we filed in Seattle. It might strike you that Seattle is a rather odd place to file a case coming out of Guantanamo. I can't think of anywhere in the continental United States further away from Guantanamo. But those of you who are legal aficionados know that Seattle is in the Ninth Circuit. And the Ninth Circuit has a, how should I put this, slightly different view of governmental power than the DC Circuit. And so Hamdan's case was actually initially filed in Seattle in the fall of 2003 on the theory that even if there wasn't jurisdiction in DC, maybe there would be jurisdiction in Seattle. You know, it was an interesting time. Fortunately, the Supreme Court mooted this issue, at least temporarily, when in June 2004, it held in Rasool versus Bush that the lower courts had been wrong in the Guantanamo cases, that in fact, at least as a matter of statute, the federal courts had the power to hear all habeas claims brought by Guantanamo detainees, whether they were challenging their detention without charge or their trial by a military commission. And so at this point, it looks like we will finally now get to the merits after fighting over jurisdiction for the better part of 3 years. And indeed, that's what starts to happen. In November 2004, Judge James Robertson of the US District Court in DC strikes down the military commissions and says they are in fact unlawful because they violate the separation of powers. Now, the thrust of Judge Robertson's logic was twofold. First, Congress had authorized some military commissions, and these are the military commissions that the court had recognized in ex parte Kieran during World War II, but these commissions didn't look like those, right? These commissions differed too substantially in their procedures, differed in their offenses, differed in their composition, et cetera. So this was not what Congress had authorized and what the Supreme Court had upheld in Kieran. And second, Judge Robertson held, in any event, the commissions violate the Geneva Conventions. And so for the first time, you actually had a federal judge invalidating a governmental policy during the war on terrorism, at least partially based on international law. Suffice it to say, the government reacted swiftly to this decision and appealed to the DC Circuit. And in the summer of 2005, the DC Circuit reversed. Well, the opinion was 3-0, although Judge Williams concurred on slightly narrower grounds. And what the DC Circuit held was that, first of all, the president doesn't have to have Congress's sanction, that he probably has some inherent power during wartime to convene military commissions. And second, the Guantanamo detainees didn't have any constitutional rights. And so therefore, there was nothing about the commissions that could violate their rights, including nothing in the Geneva Conventions that could protect them. I'll say it this way. At that point, we thought we had lost. We put together a cert petition. We put a lot of work into it. We got a few amicus briefs in support of the cert petition. But the Supreme Court had actually acted rather emphatically in 2004, and we thought they were done. And that there was very little chance that they would grant certiorari in our case in Hamdan. This is why I am not a gambler, because in November 2005, the Supreme Court did in fact grant cert, and it granted certiorari to hear this exact case. And part of what's interesting about that is that in the interim, Chief Justice Rehnquist had passed away, and Judge Roberts was confirmed to replace him. Roberts had been on the panel in the DC Circuit, which meant that he could not participate in the Supreme Court. So the court granted cert even though, first, there was no circuit split, second, the government had won, and third, there were only 8 justices participating. So we thought this was a decent sign that maybe we had some sympathetic votes on the court. At this point, Congress comes back into the story. Congress had basically not done anything on the question of Guantanamo since the AUMF in September of 2001, prompted at least largely by the grant of certiorari in Hamdan. Congress, in December 2005, passes the Detainee Treatment Act. The DTA does a lot of things. As relevant here, the 2 most critical things it does is, first, it creates statutory appeals from a final military commission conviction. So whereas before the DTA there had been no direct appeal from a commission, all you could bring was a habeas petition, the DTA says no, now there will be a direct appeal, albeit a limited one, in the case of a conviction in a military commission to the DC Circuit, the Federal Appeals Court in Washington. But otherwise, the DTA at least purported to take away all jurisdiction over Guantanamo-based habeas petitions. In other words, Congress in the DTA purported to overrule the Supreme Court's Rasool decision by saying there will be no habeas from Guantanamo. All that there will be are these narrow appeals of a military commission conviction or of, if you're not being tried by a military commission, your status hearing to the DC Circuit. The reason why this is a really big deal is because now, instead of just arguing that we were right on the merits, we also had to convince the Supreme Court that they had the power to reach the merits. Suffice it to say, it's not every day that a party in the Supreme Court files a motion to dismiss, but that's what the government did. The government filed a motion to dismiss 2 days, I think, after the Detainee Treatment Act was passed, saying that the Supreme Court no longer had the power to hear this case. So even though we thought we were finally getting to the merits, in fact, we had to go back and fight once more over jurisdiction. This is sort of, I can elaborate on the strategizing in the Q&A if folks are interested. Suffice it to say there was a lot of head scratching about how to frame the jurisdictional argument. But what we ended up arguing in the Supreme Court on jurisdiction is that Congress didn't really mean to take away jurisdiction over Hamdan's case. I mean, yeah, they said so, but they didn't use really clear words. And the non-lawyers in the room are laughing, but the lawyers are like, oh, clear statement rules, constitutional avoidance. Right, so we found every single case out there for the proposition that if a statute is susceptible to two readings, you read the one that doesn't raise constitutional questions. And we also found some rather useful language in a very, very small provision of the DTA that said that part of it applied to pending cases. And what we argued was, well, wait a second, if Congress says part of it applies to pending cases, isn't the natural inference that the rest of it doesn't? The other part of this that I think is worth noting is it's distinctly possible that the part of the DTA that referred to pending cases was written by members of Congress who were sympathetic to Hamdan's cause and who wrote it specifically for the purpose of creating this exact ambiguity. But I'll go back to why Justice Scalia is right about legislative history later. Now, what happens is the Supreme Court ultimately buys this. And in June of 2006, the Supreme Court, 5-3, holds that the DTA did not, in fact, take away jurisdiction from Hamdan's case, and the court proceeds to reach the merits. And what the court says is they basically affirm the reasoning of Judge Robertson in the district court. The military commissions were not consistent with what Congress had authorized. They went beyond what the Geneva Conventions allowed, and they were just sort of too much of a departure from established precedent, established practice. How are they a departure? Well, one of the most important parts of the holding, albeit one that only had 4 votes, was the notion that Hamdan's central charge, that he had basically, well, not basically, that he had committed conspiracy in violation of the laws of war, was not in fact a war crime. That you could not try the crime of conspiracy in a military commission because conspiracy, like jaywalking, is not a violation of the laws of war. I've never drawn the conspiracy jaywalking analogy before, but and indeed there were 4 votes for this proposition in Hamdan. But more generally, the real crux of the Supreme Court's decision written by Justice Stevens is that Congress had authorized a particular kind of military commission, and this wasn't it. And the reason why that was a particularly important holding, coming when it did in the summer of 2006, is because it cut against the central constitutional argument that characterized the early years of the Bush administration, which was that whatever Congress had provided didn't matter because the president had large swaths of inherent constitutional power to act against enemy combatants as he saw fit. Right? Hamdan is a 177-page decision, but as I tell my common law students, only one footnote matters. And it's the footnote where Justice Stevens says, the president has no power to act in excess beyond that authority which Congress has provided. That sounds like an elegant proposition. It sounds like one that solves the case, and it cuts against the Bush administration's argument about the torture statute, the Bush administration's argument about the wiretapping statute, and a series of other claims that the Bush administration had made in the years leading up to Hamdan. Now, the court did not take this on directly, but it was a rather important symbolic gesture, I think, in a case otherwise full of statutory interpretation. So Hamdan wins 5-3, and this is why in my bio it says I was part of the legal team that successfully challenged the military tribunals at Guantanamo. But success is an interesting word in this context, because Hamdan, the Supreme Court's decision, provoked another statute from Congress. Right? Indeed, specifically at the invitation of both Justice Kennedy and Justice Breyer, Congress in October of 2006, because the month before midterms is the right time to do all this kind of stuff, passes the Military Commissions Act of 2006, the MCA. And the MCA is important in several respects. First, the MCA provides the precise statutory authority that the Supreme Court in Hamdan held had been lacking. Second, the MCA prescribes 28 specific offenses that can be tried by military commissions established under the Military Commissions Act, whereas before, the military commissions could only try offenses that were recognized violations of the laws of war. Third, the MCA applies those crimes, those offenses, retroactively, so that for everyone who was already at Guantanamo, they could be tried under these new offenses. And fourth, and most importantly, the MCA, again, takes away the federal habeas jurisdiction of the federal courts. And this time, to avoid any sneaky lawyers from doing what we did in Hamdan, Congress basically says, oh yeah, and we mean it. Pending cases, subsequent cases, previous cases, the MCA applies to any claim arising out of Guantanamo. So suffice it to say, there was no longer this legalistic, the statute doesn't apply argument. Instead, now the question is, did Congress have the power to divest the federal courts of habeas jurisdiction over Guantanamo? And you probably know the answer. In June 2008, in a case called Boumediene versus Bush, a 5-4 majority of the Supreme Court says no. Says that the suspension clause of the Constitution, which protects the privilege of the writ of habeas corpus, has full effect at Guantanamo Bay. And so therefore, the Guantanamo detainees are entitled to habeas or something that looks just like it. And what the court goes on to conclude in Boumediene is that the MCA and the review it provides is not an adequate substitute. Let me just step back for a second. What should be telling about this is, again, all the litigation is not about the merits, right? Again, the litigation is about jurisdiction. It's about, do the federal courts actually have the power to decide these cases? That had been the pattern from 2001 till 2004. That was a large part of what the fight was in Hamdan. And from October 2006 to June 2008, that was the issue again. So all this fighting over jurisdiction, very little over the merits. Finally, in the summer of 2008, after Boumediene, the military commissions can actually go forward. And so Hamdan is tried by a military commission for conspiracy, even though 4 justices had said it wasn't a war crime, and for providing material support to terrorism, another offense defined by the Military Commissions Act of 2006. He's convicted, and he's sentenced to 60 months or 66 months, forgive me, in prison. Now, the reason why that number is particularly telling is because the members who sentenced him asked the judge whether they could include time served. And the judge said yes. So by sentencing Hamdan to 66 months, what the members were actually doing was sentencing him to 5.5 months on top of the time he had already spent in military custody at Guantanamo. So Hamdan was actually released in early 2009 and sent back to Yemen, where, so far as I can tell, he is flying below the radar as much as possible. So if you were paying attention, you may remember that I said Hamdan's case is still going. Well, it is, because even though Hamdan was released, he appealed his conviction. And he appealed his conviction to the Court of Military Commission Review, this bizarre intermediate appellate court that Congress created in 2006 to go between the trial court and the DC Circuit. Hamdan filed his appeal in the fall of 2008. It has not yet been decided. This is a court, by the way, that has no other cases. I want that job. Now, it may seem silly to have all of this wrangling over a case about a guy who has long since been released from Guantanamo and sent home, but part of the problem is that this is not going to be the last military commission trial. The Obama administration announced a couple months ago that it intends to try the so-called 9/11 defendants in a military commission, and so it's actually rather important to answer fundamental questions about the military commissions created by Congress in 2006. Does Congress have the power to define offenses that triable by a military commission that are not recognized as violations of the laws of war? Right? That's one big question. Even if Congress has that power, can it apply those offenses retroactively, such that an individual can be convicted for conduct committed in 2001 under an offense that was created in 2006? These are fairly significant questions that are probably worth answering sometime before the 9/11 defendants are tried, and this is why this case still matters. And I think in some sense this dovetails with the larger point. Finally, in Hamdan, in the detainee cases that are currently going through the DC courts, we are seeing litigation of the merits, of the scope of Congress's power over military commissions, of the scope of the government's power to detain non-citizens under the AUMF, of the powers of the federal courts to release detainees once they are held to be no longer detainable. And this is good, and I think these cases are fascinating, and we can talk a bit more about them in the Q&A. But the most interesting part to me is how long it took us to get here, right? It's been 10 years, and it was really the summer of 2008 before we actually finally started to get to serious, hard questions on the merits. Folks may have different views than from mine about how the courts are doing on the merits of these issues, but I think the larger point is it's about time. And if anything, hopefully what we've learned over the last 10 years is that the more that we obsess over questions of process and the more that we have to sort of remind ourselves of fundamental structural principles about the role of the courts, the longer it takes to actually answer the hard and, in my view, far more interesting questions. So I'll stop there, and I'd love to hear your questions. Sir, in the back.
From the very beginning, I mean, you've done a wonderful, clear job of that. From the beginning, I've never understood how the Constitution permits the executive branch to take judicial functions because we have separation of powers. And I don't see why the MCA Act is unconstitutional.
Well, so I think, the question all along was first whether the courts had the power before the political branches acted. Right, so at least in the early cases leading up to Rasul in 2004, Congress had not tried to take away jurisdiction. And part of the problem is that there was the Supreme Court decision from 1950 called Johnson versus Eisentrager that had been misread for the proposition that non-citizens outside the United States were not entitled to habeas. And so I think part of the problem is not that the political branches in the early part of this decade had affirmatively taken away the court's power, but rather they had argued that this old Supreme Court case had done it to themselves, right? That the courts had basically stopped themselves. That at least gets you to 2004, right? And then I think you're exactly right that the central issue in Boumediene, the 2008 case, was whether now the political branches could affirmatively take away habeas review. The Supreme Court said no, but there are two important caveats. First, it was 5-4. So 4 justices thought they could. And second, in a follow-on case, the DC Circuit, the Federal Appeals Court in Washington, has said that Boumediene, the Guantanamo case, doesn't apply to Bagram, to our detention facility in Afghanistan. So at the moment, there actually is no habeas for detainees at Bagram. So I actually share your concern about usurping the judicial function. We're not all the way there yet. Sir?
It's not really the central topic, but could you just briefly fill us in on how the saboteurs in Ex parte Kirin came to call the FBI? I mean, they didn't call as soon as they landed, right?
Oh man, okay, I'm gonna give you the quick version. There are about 5 books and a movie, and I would encourage you to go find them if you want some fun holiday reading. So the short version is there were 2 teams of 4 saboteurs each. And they were landed by U-boats, one on the southern coast of Long Island and one off of Jacksonville, Florida. And the best part of the story is the Long Island 4. So in the summer of 1942, if you had to guess, how many Coast Guard officers do you think were patrolling the southern shore of Long Island on foot?
2.
0, 2, split the difference, 1. His name was, I think, Edward, or I don't remember his first name. His name was Cullen. One guy for the southern shore of Long Island. I'm from New York City. I don't get out to Long Island much, but I hear it's long. And the remarkable part about this story is that the 4 saboteurs landed on the beach, and they were almost immediately discovered by Cullen. They picked like the one spot where you shouldn't land. The other part about the story is the saboteurs actually wore uniforms. So that if they were interdicted while they were literally crossing the coastline, they would technically be soldiers, right? They'd be prisoners of war. But the second they get onto the beach, they bury their uniforms, they bury their ammunition. Cullen sort of sees them doing this, but not really. And he stops them and he talks to them and he says, "What are you doing?" And he's a little bit surprised that only one of them seems to be able to speak English. I'm telling you, you can't make this up. Eventually, Cullen lets them go, but he goes back to the station, he files a report, and he and his supervisor go back to the site where they actually dig up the uniforms. So the Coast Guard knew, and the Coast Guard tried to sort of tell whoever the relevant authorities were that there were 4 probable Nazis on the East Coast. One of the Nazis, the ringleader, had actually apparently always been determined to turn himself in, and was never actually intent on carrying out acts of industrial sabotage and espionage. And so he was the one who calls the FBI. It had actually been his plan all along that he thought he'd be better off in a US prison than in a German concentration camp, or whatever you would get if you were a German deserter. So he calls the FBI and they don't believe him. And then he calls back and they say, well, come in for an interview. And finally, about this point, the FBI starts figuring out what's going on. So they were all actually supposed to rendezvous in Cincinnati a couple weeks after they landed. And it's in Cincinnati that the FBI arrests the remaining saboteurs with the help of the ringleader guy. So it really is quite the Keystone Cops kind of scenario. And it leads to ex parte Kieran and this great Supreme Court case.
What month of 1942 was that?
They landed.
World War II, that it would be so funny here.
Yeah, I mean, they landed, I think they landed in either May or early June.
It's like Hitler was totally on top in Europe at this moment.
Yeah, no, I mean, the panic was very real. But the interesting thing is, so the military commissions are convened in July. It must have been late June, because the commissions are convened in July. And at the time, FDR's position was no judicial review for the saboteurs. And he's eventually talked out of that by his subordinates. But so the saboteurs simultaneously have military commission proceedings going on in one room in the Justice Department in Washington. I think there's a plaque actually outside the room. And their lawyers, who are US Army personnel, are simultaneously pursuing habeas proceedings in the federal district court in Washington, apparently with Justice Frankfurter helping them. At least to solve the jurisdictional issues that were arising. The court actually comes back to sit in special term, something that they almost never do. They all come back in the middle of July to hear the oral arguments in Kieran, and then they issue a one-paragraph order saying this is all okay on, I think it was July 31st or August 1st, and that they say, we'll write the opinion later. 6 of the saboteurs were executed. The 2 who weren't both had at least some ties to US citizenship. And the court later files the opinion, but there's actually a really, really messy story about the internal politicking on the court about the opinions, because they came to realize that they didn't quite have the law where they wanted to. And it's part of why Kieran's so controversial.
Is there a part of an answer to the question the gentleman in the back asked before, the fact that the executive, that is, within the management of the army going back into the 19th century, there were always courts to try soldiers who were miscreants?
There were, although, I mean, the military justice system is an interesting example because, I mean, our military justice system is as old as the country itself. The military justice system, the courts-martial. They're as old as the country itself, but until 1950, there was no procedure to appeal a court-martial conviction to a court. There's no appeal, right? So what you would do, if you were a service member convicted in a court-martial before 1950, you had some review within the executive branch in the military, and then if you really thought there was a defect in your proceedings, you could bring a habeas petition, a collateral action. The only problem is you could only claim in the habeas petition that the military court lacked jurisdiction. You couldn't say that they committed an error of fact or an error of law. You could only say they didn't have the power to try me. And that's why all of the early military cases are jurisdictional challenges. Can you try a civilian? Can you try someone who retired from the army, et cetera? Because those were the only challenges you could bring until the early 1950s. Yeah?
So thinking about executive power in the kind of Youngstown Steel framework, right? Like,
which you all know, right?
I was getting that, right? Like, the executive is either acting kind of with the will of Congress or against the will of Congress or in some sort of
zone of twilight.
Yeah. It sounds to me, right, like the part of the case, most of the case you were talking about, it seems like the court was finding that the executive action here, because the AUMF authorized some commissions, the implication was that executive action was against the will of Congress in this kind of no-go zone. But the Stevens footnote you were quoting made it sound like, right, Stevens was talking about executive action in the zone of twilight, and that there was no, that executive power was pretty limited unless you had congressional authorization. What's your...
Or at the very least, because Congress had acted, executive power was very limited. So the Stevens footnote, Youngstown, for the non-law school geeks out there, is the canonical Supreme Court separation of powers decision from 1952. And Justice Jackson's famous concurrence in Youngstown suggests that there are three categories. There's where the president's acting with congressional approval, without, and the middle one where who the hell knows. What's fascinating about Hamdan is that the very footnote that I mentioned cites to Justice Jackson's concurrence in Youngstown. And it cites not just to the concurrence, but the specific pin cite is to the part of his concurrence talking about the third category, where the president is acting in the face of congressional will. The reason why that's telling is because Justice Jackson did not say that the president therefore loses. Right? The whole point of Jackson's concurrence is that there will still be some cases where the president wins even though Congress has attempted to constrain him. And so the remarkable thing about that footnote is it miscites Justice Jackson's concurrence in Youngstown for the proposition that because Congress has spoken, the president is stopped from going any further. This is going to sort of out-nerd even myself, but the real citation to Youngstown should have been to the Clark and Burton concurrences, which both said that. But of course, Jackson is the one we hold out as the... This is actually, to me, the one analytical flaw in Hamdan, is that what Justice Stevens was really saying is that this is one of those cases where we're not only in Category 3, but where Congress wins and the president loses. And Stevens never bothered to explain why. Right? He never went out of his way to say why, in this particular case, that's the end of the inquiry as opposed to just the beginning. Behind you, yeah.
When I was in grade school, we learned the phrase ex post facto, which essentially meant you could not be prosecuted for a crime that you committed before it was a crime. So I'm astonished to find out that's still in question. Can you explain something?
Sure. So the ex post facto issue, which I think is really, when you pull away all the layers of politic and rhetoric, I actually think this is the $64,000 issue before the military commissions right now. The government's response is twofold. First, they say these offenses already were violations of the laws of war. Congress just hadn't codified them. Right? So the statute that governed the military commissions before 2006 authorized the president to convene military commissions for offenses against the laws of war. And so if they were in fact offenses against the law of war, conspiracy, material support, et cetera, then the government argues there is no ex post facto problem. All the Congress has done is provided additional codification. What's interesting about that argument, besides the fact that it's dubious, is that 4 justices in Hamdan had specifically held that conspiracy was not a violation of the laws of war. And so even if that's not binding, because it was only 4 justices and not 5, it's fairly persuasive authority for the proposition that conspiracy wasn't a war crime. So there are 2 different questions. Can Congress define offenses that are or are not marginally violations of the laws of war? And even if they can they do it retroactively? But they sort of merge, because if these offenses were violations of the laws of war, then presumably they were in 2001, whether or not Congress had said so. Does that make sense? So in other words, let me try that again. So the question is, let's just take conspiracy, right? Was conspiracy a violation of the laws of war in November of 2001, right? If the answer is yes, then there's no ex post facto problem. Right? Even though Congress hadn't said conspiracy as such as a war crime, Congress had said, yes, you can have military commissions for violations of the laws of war. If the answer is no, then there are 2 different problems. One is ex post facto, and the other is Congress's power to subject to military commission offenses that aren't war crimes. So that's why I think you're exactly right. The ex post facto issue is critical. And I dare say I think that's probably what the Court of Military Commission Review is hung up on right now, and why it's taken them a little bit of time to decide these appeals. Sir, in the back. Behind you, sorry.
Why should we care about this? Why should we care whether these people are tried by military tribunal or by a civilian court? What are the stakes involved here for the ordinary citizen?
Well, I think that's a great question, and I think the stakes are twofold. First, I think, and this is probably the big picture one, military commissions are defined by their exceptional nature, right? The whole justification for military commissions is that there's some reason why the civilian courts can't handle these offenses. And one of the ironies about the last 10 years is that we actually haven't had that conversation, right? Conspiracy, material support, all of the offenses the 9/11 defendants are charged with are also crimes under the Federal Civilian Criminal Code, right? And therefore can also be tried in Article III court. So the first question is, why are military commissions even necessary? And if the answer is because the evidentiary rules are more lax, or because a conviction is more likely, that raises to me serious legitimacy concerns, right? We're having these proceedings simply because it's more likely we'll convict these guys. That doesn't sound like a very strong justice system to me. But more directly, right, and I think this is probably the more, I think, salient point. The Supreme Court, at least until 9/11, had always drawn a very sharp line between military trials for belligerents, for soldiers, and military trials for civilians. So in Ex parte Milligan after the Civil War, in Duncan versus Kahanamoku, the Hawaiian martial law case that I suspect very few of you have heard of after World War II, as Paul looks at me cross-eyed, these are all for the proposition that the line between the military and the civilian has to be observed, even when we're talking about foreign militaries versus foreign civilians. And I think the more we blur that line, the more that you're trying people for offenses that aren't traditionally war crimes, and the more you're trying individuals who aren't necessarily belligerents, the more we risk the erosion of that very bright line.
There's one other, just to follow on the two things that you just said. The more that we are going to be eternally at war. Wars used to begin and end, and now it becomes a problem for a third reason, is that there is no end to a war if a war is there are terrorists somewhere in the world who might at some point that we don't know threaten our freedom or threaten something on our territory. So that's the third.
Well, and I think that dovetails with this week, right? So I mentioned really quickly at the outset that Congress this week has been considering the new AUMF. And one of the remarkable things about this new language in the National Defense Authorization Act is that it untethers military force in the war on terrorism from 9/11. What do I mean by that? If you go back and look at the statute Congress passed 1 week after September 11th, it actually specifically refers to persons, organizations, or nations who were responsible for the attacks of 9/11. Right, and so the theory was we weren't at war with international terrorism, we were at war with the groups who were directly responsible for 9/11. The language in the new AUMF eliminates that and says we are at war with Al-Qaeda, the Taliban, and associated forces. And associated forces are defined as any group anywhere in the world that is supporting Al-Qaeda or the Taliban, whether or not that support comes in the context of hostilities against us. Right? So any terrorist group around the world that in any way, shape, or form is supporting Al-Qaeda all of a sudden becomes the subject of our military force. And I think that's a very good point about why it's that much more important to preserve the distinction between the traditional military regime and the civilian one. Yeah?
Could you review briefly where we are on the 100+ left at Gitmo in terms of the categories? My understanding is that there's a third category of people who may never have any trial in any system of court.
The 48, they're called by the Guantanamo habeas bar. So we're down to, I think 171 is the current number of detainees at Guantanamo, down from a high of 778. President Bush released a lot more Guantanamo detainees than President Obama has, but who's counting besides defenders of President Bush? And others. But of the 171, they break out into a couple of categories. The first category is those who have been cleared for release, but not yet released. And within this category, the biggest subset is Yemenis, because we've had, how should I put this diplomatically, difficulties ensuring that they will be released into the right kind of conditions with the right kind of oversight by the government of Yemen if they're sent back to Yemen. But it's not just Yemenis. Some of you may also be familiar with the case of the Uyghurs. These are ethnically Turkic Muslims from Western China There are only a couple of them who are still at Guantanamo, but they're also in that category. The second category is those who are slated for trial, either in a military commission or in a civilian court if Congress were to relax the rather bizarre restrictions on transferring people to trial by civilian court. And then the third category, and this is I think the one you're getting at, is the 48. And the 48 is the category of individuals for whom the government has basically said we can't really try them. Primarily because there either isn't enough presentable evidence that can be admitted in court, or because the evidence that exists is so secret and would require so much security that it's not practical to use that evidence in court. But we also can't release them because they're too dangerous. And I think in the long term, it's those 48 that are the real tricky issue going forward. You know,
is there any precedent of that kind of detention in American history?
Well, it depends on what you mean by that kind of detention. So there are two different categories. There are two different paradigms for detention without trial. There's the military paradigm, which is detaining prisoners of war or unprivileged belligerents, which is supposed to expire with the end of hostilities. Of course, as you pointed out, there's no necessarily obvious point when that's going to happen. But there's also civil paradigms for detention without trial. So for example, we have in this country civil commitment for dangerous sex offenders after they've served their prison sentences. We have detention of non-citizens pending their removal from the country, even though they've committed sometimes no crime. And we have detention of individuals who have been indicted but not yet tried under the Bail Reform Act. And we have quarantine. Right, so we have 4 different categories of non-criminal detention, all of which are predicated on individualized showings of dangerousness. Right, in each of those categories, the government has to go before a magistrate and say, this person, if released, would present a threat to the community, and that's why you have to be able to hold them. I don't know how good of a precedent those are for these 48. But I think that's part of why you saw the Obama administration a couple months ago release this new executive order that provides for periodic review. Because I think part of what they're conceding, which is not something the DC Circuit has said, is that there should be periodic review. We should be reconsidering whether for each of these 48 detainees, those circumstances are no longer present. Just one last footnote before I sort of lose you all in the haze of case law. On the notion of can you detain someone on those grounds indefinitely? So in 2001, in June of 2001, shortly after we walked out of here, right? Well, ran because it was raining. Were we the first class to graduate inside? It was sad. All right. Anyway, in June of 2001, the Supreme Court decided a case called Zadvitas versus Davis. And Zadvitas is interesting because Zadvitas was about the category of individuals I mentioned before, non-citizens pending removal. Right? So you had non-citizens who had deportation orders entered against them, who were sitting in prison because we couldn't effectuate their removal because their home country wouldn't take them, or because it would violate international law to send them back to their home country, or any number of other things. And what the Supreme Court said in Zadvitas is, well, this is a tough situation, but you really shouldn't be able to hold these individuals for longer than 6 months. Right? So Zadvitas stands for the proposition that the due process clause of the Fifth Amendment imposes a 6-month limit on how long you can detain non-citizens in this context without trial. The reason why that's interesting is because in Justice Breyer's opinion, in Zadvitas, Justice Breyer's calling to correct me. In Justice Breyer's opinion in Zadvitas, Breyer said 6 months. That's all the due process clause allows. And then he drops a little disclaimer. Of course, he says, we're not here concerned with cases of terrorism, where other considerations might justify longer periods of detention without trial. That was the Supreme Court's last decision on the merits before 9/11. And if that isn't ironic, I don't know what is. So I guess that's sort of my answer to your question. The only other thing I would say before I forget, the last category of precedent is there's a statute that actually very few people have heard of called the Alien Enemy Act. And the Alien Enemy Act was passed in 1798. And it authorizes the detention of any national of a country with which the United States is at war. So in fact, pursuant to the Alien Enemy Act, we detained Germans during World War I, we detained Germans and Italians during World War II, even though they weren't belligerents. The problem with the Alien Enemy Act is it only applies when we've declared war against a country. There are no alien enemies under the current paradigm. So those are all the precedents that are out there. I think we have time for one more question, Jesse? Or two more questions.
This is sort of a kind of a general question, which is that we've talked a lot about precedent and case law and everything like that.
Law stuff.
Taking a step back, can you give us reasons for lack of a better word, any reasons for optimism about the direction that we're heading, in the sense that we do seem to be moving in a direction of, permanent and endless war and things like that?
Sure. Optimism. Let's see. Well, the Mets just sold a 49% stake, so that gives me optimism. Right? Yes. So I think there are some reasons to be optimistic. I think there are also some reasons to be frustrated with the current administration for not being more optimistic. So what's optimism? Optimism is we're not holding anyone new at Guantanamo. Right? The reality is that we're holding fewer and fewer individuals without trial all over the world, including at Guantanamo. We haven't sent anyone to Guantanamo since early 2007. Optimism is the administration has abandoned some of the more extreme arguments that its predecessors made about the relevance of international law in these cases, about the scope of the president's inherent constitutional authority in these cases. The administration has relied far more specifically on Congress. Optimism is 620 of the individuals who were at one time held at Guantanamo have been released. Whether because of court orders or not, whether by President Bush or President Obama, that's a positive development. So there's room for optimism. That being said, I think the administration has shown some odd restraint when it comes to these issues. So after making closing Guantanamo such a critical issue, right, after signing an executive order on the second day of President Obama's office, saying they will close Guantanamo within a year, here we are almost 2.5 years later, and it's still there, and it's not going away anytime soon. Right? The administration has not really stood up to Congress, as Congress has made it harder and harder to close Guantanamo, to have these individuals tried in ordinary civilian courts, et cetera. So I think there's optimism. I think there could be more optimism. And indeed, I would have hoped that the operation that killed Osama bin Laden would have brought into perspective the fact that a lot has actually happened in 10 years and would have moved us toward thinking about where we go forward. Instead, if this week's conversation in Congress is any indication, the operation against Osama bin Laden seems to be feeding a mentality to go even further. Right? Who else can we go after? That to me is not necessarily optimistic. Yeah?
Care to make any quick prognostication? Because the Supreme Court has gone through such changes, Stevens is gone, et cetera, et cetera. How do you, without getting very complicated about it, see the future of these issues on the new Supreme Court?
How do I see them? Well, I think the most important thing in the short term is the Supreme Court is going to be quiet on these issues for a while. And the reason why that's true is because I suspect that eventually Justice Kagan will become a vote quite reliably alongside Justice Stevens's. The problem in the short term is that she is recused from any case she worked on while she was the Solicitor General, including virtually all of the current Guantanamo cases. What that means practically is that if you count the justices on the court, in Boumediene in 2008, there were 5 who thought that habeas extends to Guantanamo and 4 who thought it didn't. Without Justice Kagan instead of Justice Stevens, it's now 4 and 4. And if you know anything about the court, 4-4 means nothing happens, right? 4-4 means the decision below is left intact. And indeed, that's why almost all of the Guantanamo cases that have come to the court in the last year have been rejected, have been denied. So I think in the long term, that 5-4 lineup we saw in Boumediene is going to hold at least until there are more turnover, more changes on the court. But that presupposes that Justice Kagan will be able to participate, which he has not yet been. One more question? You guys thought you were about out of here. Yeah, last question.
Did anybody ever argue that Guantanamo Bay is American soil?
Yes, quite vehemently. Guantanamo, so this is a funny story, last inside story of the talk. We talked at one point early in the Guantanamo litigation about how if you couldn't file in a US court, that must necessarily mean that you can file in a Cuban court. And so we actually did some research into how you would file a writ of habeas corpus in Cuba. Because it occurred to us that the courts of Fidel Castro would be only too happy to exactly. Now, with regard to the Guantanamo as part of the U.S., the reality is that that was the theory on which Rasool was argued in 2004, and that was a large part of the theory on which Boumediene was argued, that it's not that non-citizens everywhere are entitled to habeas, it's that the United States exercises a particular and unique kind of sovereignty over Guantanamo that it does not exercise elsewhere in the world. And that was a large part of Justice Kennedy's concurring opinion in Rasool, and it was a large part of his majority opinion in Boumediene. That it's not that Guantanamo is outside the US, it's rather that Guantanamo is as within US control as anywhere within the US itself. And that's part of why, at least so far, the rationale of these cases has not been extended to Afghanistan or other places outside of Guantanamo. All right, thank you very much.